Hello and welcome to Stearns Weaver Miller's special program, Breaking Through the Noise. It's all about shining a light on the most important labor and employment issues that employers across Florida and the country are facing right now. I'm your host, Lori Jennings, and we're so glad you're joining us. As you know, for the last 30 years, the law firm of Stearns Weaver Miller has put on a live, all-day conference attended by hundreds of people just like you, the top human resources leaders across Florida. Well, unfortunately, due to COVID, the seminar had to be canceled yet again this year. However, because businesses are quickly reopening their doors, Stearns Weaver Miller wanted to help you break through the noise by addressing employment issues that you'll need to know about in this post-pandemic business environment. You may know Bob Turk. He is chair of the firm's Labor and Employment Department. And Bob is the one who came up with this very creative idea to reach out to everyone by video. So who better to kick off all the action? I'm going to call you Mr. Producer from now on.
Well, thank you, Lori.
You're welcome. It's a good title.
Thank you. Well, as we aren't able to hold our annual conference for our clients and friends, and we know almost everyone is Zoomed and webinared out, I thought we'd do something completely different. A 2-hour live in-studio presentation. Unfortunately, we can't provide our famous popcorn this year, as we've done at our all-day annual past seminars, and I've been told to limit my juggling. However, as you sit back and watch at your leisure, feel free to microwave some popcorn and join us for the next 2 hours. Now, because our program time is limited, we can't go into extreme detail on every topic. Instead, we'll be following up with a series of webinars on the most important topics for you. So look for a list of the webinars coming your way very soon. For those of you who are HR professionals, we've applied for HRCI credits and SHRM credits. For attorneys, we've applied for CLE credits as well. So we'll send that credit information via email to you in the next few weeks. So Lori, what do you say you give everyone a preview of what we're going to see in the next 2 hours?
I'd be happy to. We have a big agenda. The pandemic has really put HR professionals like you in the hot seat with some of the most critical, intense, and rapidly changing workplace issues you've ever experienced. And HR folks have taken on more roles than you've ever imagined. So throughout this program, you're going to meet 6 professionals from vastly different businesses across Florida who'll share what kept them up at night during the pandemic. You'll hear from EEOC Commissioner Keith Sonderling. We'll also have discussions on social justice and diversity issues, hot topics in litigation, the upcoming hurricane season, the confusion in applying for leave under the FMLA and ADA, and employee benefit issues. We'll also chat with 5 attorneys in their 30s about where they see future employment law issues heading. So to begin, let's meet the labor and employment attorneys who'll be presenting today. Since you won't be able to mingle with them as in the past, we've asked each one to introduce themselves and tell you the very first jobs they ever held.
I'm Lisa Berg. My first job was as a congressional intern in Washington, D.C. I worked for Congressman Matt McHugh from the 28th District in New York.
Hi, my name is Paul Crusette. My first job was a server at Allen's Drugs in Miami, Florida, and my pay was $2.16 an hour plus tips.
Hi, my name is Sharon Quinn Dixon. My first job was in the fabric department of the Zaire department store in Alsip, Illinois. I made a grand total of $1.65 an hour.
My name is Eric Gabriel. I had my first job when I was 8 years old, delivering newspapers. Those of you who are over 50 remember kids used to deliver newspapers. For those of you under 25, there used to be these things called newspapers.
Hi, I'm Giselle Gutierrez, and for my first job, I worked at my high school in the attendance office, earning $5.25 an hour.
Hi, I'm Melanie Lightman. My first job was at Brugger's Bagels, and I made $5.50 an hour with no tips doing food prep.
Hi, I'm Janet McHenry. My first job was a sales clerk at a high-end department store in Albany, New York called Flaws. At that job, I earned $1.25 an hour.
My name is Andy McLaughlin. My first job was construction labor at $7.25 an hour.
Hi everyone, I'm Ingrid Ponce. So while not officially my first job, one of my first jobs was actually working at Universal Studios in Orlando on the original King Kong ride Confrontation. I can't tell you how much I got paid per hour. I just can tell you I got lots of free tickets to Universal that summer.
Hi, my name is Tom Rain. I was a youth golf instructor at Palmetto Golf Course here in Miami, and I made $10 an hour.
Hi, I'm Glenn Rissman. My first job was a counselor in training, a CIT, at Pinecrest Day Camp in Fort Lauderdale. And there was no pay. We got a talking calculator at the end of the summer.
My name is Andy Rodman. My first job was serving billions and billions at McDonald's. $6 an hour, Stoughton, Massachusetts, and I got an extra $1 an hour when I closed.
Hi, my name's Eric Roth. My first job was laying tar paper on the roofs of warehouses around the airport. I got paid $2.50 to work over the summer. It wasn't worth it.
My name is Rene Ruiz, and my first job was washing cars in South Miami for $5 an hour.
Well, hi, I'm Bob Turk, and my first job was a busboy in Dino's House of Pancake in Myrtle Beach, South Carolina. My pay was $1.25 an hour with no tips.
Hi, I'm Stephanie Turk, and my first job was at a nut house. Morrow's Nut House in Coral Square Mall in Coral Springs, Florida. And at the time, I was paid $5.15 an hour.
The U.S. Equal Employment Opportunity Commission is responsible for enforcing federal laws that make it illegal to discriminate against a job applicant or an employee because of certain protected characteristics. Keith Sonderling is one of 5 commissioners in Washington, D.C. with the EEOC. He participates in the development and approval of commission policies, issues discrimination charges where appropriate, and authorizes the filing of suits. Prior to his confirmation last year, Commissioner Sonderling served as the acting and deputy administrator of the Wage and Hour Division at the U.S. Department of Labor. In our first segment, shareholders Bob Turk and Ingrid Ponce caught up with Commissioner Sonderling about various post-pandemic issues from the EEOC's perspective.
Thank you, Lori. Ingrid and I are here with EEOC Commissioner Keith Sonderling. I've known Keith for 8 years when he was in private practice here in Florida.
First of all, thank you for having me. It's really an honor to be a part of your presentation, and I'm just excited to be talking to you, and especially my Florida crowd. So yes, when I left South Florida for Washington, D.C. in 2017, it was certainly a new experience for me, having lived in Florida my entire life. And Bob, I remember calling you, and you were very much encouraging me to leave home and come to DC. And I've really had an incredible experience up here so far.
So tell us a little bit about your tenure as an EEOC commissioner, and how long is your term at the EEOC?
So I was confirmed in September of 2020. I went through the Senate confirmation process, which took me 14 months. It was quite the experience going through all that, but it was successful at the end of the day. So my term ends July 1st, 2024. So EEOC commissioners have 5-year terms, which are staggered. So, but the fall of 2020 brought so many changes to the EEOC. It's the first time the EEOC now has a full 5-member slate since 2016. And currently there are 3 Republicans and 2 Democrats, because it is a bipartisan commission, and all 5 of us are here. But significantly, Republicans have a voting majority, a first since 2008. But the dynamics will change once again. Next July 2022 is the date to watch. That's when the first Republican, former Chair Janet Dillon, who's now Commissioner Dillon, her term ends.
That's great. That's really good insight for employers to know, because they don't always necessarily understand how the EEOC is different from the administration. So that's really helpful. Thank you.
Well, Keith, let me ask you too. The EEOC, I know when we talk about enforcement, also doesn't just investigate charges of discrimination. They can sue employers. And our regional attorney, Bob Weisberg, is well respected here out of the Miami District Office and has brought a number of litigation claims. Out of DC, has there been a change in how litigation is going to be conducted going forward this year?
Well, yes, the EEOC has its own independent litigating authority, and not all federal agencies have that. So we're unique in that regard, similar to the Department of Labor. So there has been significant changes in the way the EEOC is going to be litigating cases. So pursuant to the new litigation delegation, by default, any case that meets the category, which I'll list, is coming to the commission for an automatic vote. So cases involving an allegation of systemic discrimination or a pattern or practice of discrimination, which could be very, very large and complicated cases. Cases expected to involve a major expenditure of agency resources. And then any other cases of law that are not settled or cases that are likely to generate public controversy. And similar with that, it's something that the Senate confirmed commissioner should have a say in and should make that decision. So anything that's not in this category, commissioners will still review. So the cases that are more generic that don't meet that list, they'll still come to the commissioners for a 5-day review period. And if a majority of commissioners believe it actually should be voted on because it is implicating a policy, we'll have the ability to do that.
That's helpful. And now I know one of the other priorities of the EEOC has been the mediation program and emphasizing mediation as an alternative to try to resolve disputes. Can you tell us a little bit about the EEOC's mediation program?
So the EEOC's mediation and our conciliation programs have allowed more people to obtain relief more quickly than litigation and provide additional avenues to recovery without waiting. Consistently, more money has been given by the EEOC to victims of discrimination through our mediation and conciliation rather than litigation. And significantly to everyone out there, especially those who have been through a lengthy charge process or have been through a lengthy investigation or litigations, EEOC's mediation services are provided not only at no cost, their average resolve time is 100 days. With COVID, we've had to do a lot of video mediation, so we're going to continue doing that as well. We really enhanced our technologies related to mediations. So they will continue to be virtual for a long time in the future. So I encourage all employers to participate in the EEOC's mediation program. As you heard, as you know, it's a successful program and it's free.
And what's the EEOC doing in terms of its conciliation? I know there's been a lot of press in the news about a change that's occurred and with a new rule.
By statute, the EEOC is required to conciliate or settle with the employer after the agency has determined reasonable cause exists to believe that discrimination or retaliation occurred. So this is in the situation where you're much further down the line and the EEOC has found that your company that there's reasonable cause to exist that discrimination occurred. But EEOC can't just go and file a lawsuit. By statute, we actually have to conciliate before we do that. So in January, we issued a final rule, which I was very supportive of regarding conciliation. And this is the most significant to change this conciliation since it started over 40 years ago when the first time there was guidelines for it. So now, in summary, during conciliation, the EEOC has to give the essential facts and law supporting the claim, finding, and demands. So the rule lists out specifically what the EEOC now will give to employers during this conciliation process, where before, there was always a gray area of what information the EEOC would give. So I'm a huge supporter of this rule. But unfortunately, to the Washington, D.C. part of this presentation, this rule was hotly contested. Congress has what's known as the Congressional Review Act, which is used. They can essentially undo a rule done by a federal agency. So right now, the Senate has voted to disapprove of the rule. The vote was 50 to 48. So now it is pending in the House. So now the full House will have to vote on it before it would eventually go to President Biden's signature. So if it does pass in the House like it did in the Senate, then it would be up to President Biden to sign. And the unfortunate consequences of that would be that this rule is gone and that these guidelines I just told you will be eliminated and the EEOC will be prohibited from doing another rule on this. So that's it. So there'll be no guidelines for the conciliation process, and the agency won't have to give that information that we're required to now by a federal rule. So it's very important that everyone pay attention to this and keep watching it. But for the time being, everything I told you is still in effect.
Now, Keith, one of the issues that we've been dealing with as labor and employment management attorneys, and we've been getting so many calls on this, is the issue of COVID-19 vaccinations. Everybody out there is trying to figure out how to get back to work, how to get back to normal, and vaccination appears to provide the light at the end of the tunnel, right? It provides this vehicle for hopefully getting us back to work and back to normal. Can you tell us a little bit about the EEOC's position on COVID-19 vaccination?
On December 16th, 2020, the EEOC updated its COVID-19 guidance to address how the administration or requirement of the vaccine intersect with the ADA and Title VII. In this guidance, again, the EEOC took a step forward and definitively stated that under the Americans with Disabilities Act, that the vaccination is not a medical examination. And then asking or requiring an employee to show proof of a receipt of a vaccination is not a disability-related inquiry under the ADA. I know that's a little technical, but for both of you as labor and employment lawyers, I think you understand the significance of this.
Yeah, I can tell you, we absolutely appreciate that, because as giving advice on a daily basis, it's very helpful to be able to say, hey, here's the guidance directly from the EEOC. So thank you for that.
Are there any other new guidances that the EEOC's issued that you would want to highlight or tell employers to take a look at online?
Yeah, we put out 3 pretty significant guidance documents last year. And with everything going on with COVID and our COVID guidance, this didn't get as much publicity as it normally would. So I just want to make sure everyone knows about it, because it's relevant to almost every industry. The first guidance was about the growing concern with the opioid addiction and employment. The guidance clarifies employers' obligations under the Americans with Disabilities Act for people taking prescription opioids and those receiving treatment for opioid addiction. Another set of guidance related to veteran discrimination and employers' obligations under the ADA and the Uniform Services Employment and Reemployment Act that apply to veterans. In recent years, there's just been a lot of post 9/11 veterans have had service-connected disabilities. Almost more than 40% of those veterans have disabilities, compared to 25% generally. And then finally, a guidance document that's well over 100 pages was our update to our religious discrimination guidance, which was the first time it was updated in over 12 years. There's been a lot of Supreme Court cases regarding religion in the workplace and religious discrimination. So it's a very comprehensive guide. It goes through typical scenarios in which religious discrimination occurs, provides guidance to employers on how to balance the needs of individuals in a diverse workplace. So now I have everyone's attention. Please check those guidance out in addition to our COVID guidance, because it's extremely helpful and timely.
Well,
Thank you so much, Keith. That's fantastic.
right. So let me thank you, Commissioner Keith Sonderling, for your time today. I am overwhelmed at the breadth of knowledge that you have and the responsibility that you carry. And I just want you to know that all of us in Florida wish you well in the coming years and look forward to the guidance from the EEOC on all the issues we've talked about today. So thank you again, and thank you all for joining us.
Thank you for having me.
COVID-19 brought unprecedented challenges for businesses, leaving many leaders and HR professionals overwhelmed and really unclear how to move forward on various issues. Now, over a year later, there are still unanswered questions. So Stearns Weaver Miller asked their clients, what keeps you up at night? Throughout the show, we are going to be highlighting answers to this question from clients across the state. Our first What Keeps You Up at Night segment features shareholder Rene Ruiz, who focuses his practice on labor relations. Rene checked in with Johnny Telechea Jr. He's the senior HR manager for Florida Crystals Corporation. Florida Crystals is a fully integrated cane sugar company headquartered in West Palm Beach. The company farms 190,000 acres in South Florida and owns 2 sugar mills, a sugar refinery, a packaging and distribution center, a rice mill, and the largest biomass renewable power plant in North America. Let's see what keeps Johnny up at night.
Johnny, good morning. How you been?
Doing okay, Renee. Good to see you.
Life has certainly been different the last year. I mean, I remember early on when the pandemic hit, just being in a state of not knowing what to do and how to handle your particular operation that has not only so many people, but spread out over such a huge geography. If you can, walk me through, as the pandemic emerged, what were the issues that you had to deal with first, and how were you able to tackle them?
Top management made a commitment that we were going to make this work, and we were going to do everything possible to plan. Like you said, not only here in South Florida, but globally. We had to get all of our top management together, basically change the culture to make sure that we're, like I said earlier, we're going to keep everybody safe, give all of our employees all the tools to keep them safe at work and safe when they got home. But it was a big challenge, and it still is. And I don't think it's going to go away anytime soon. I think with a vaccine that's come out, a lot of our employees are becoming fully vaccinated. That's helped us. But It's going to be an ongoing process. And, one of the things that helped us, we're an essential operation here in South Florida.
With all the uncertainty the last year, one of the things that I was always happy that remained certain was that every time I went to the grocery store, there was still sugar on the shelf. So you guys, kept doing what you had to do. I would imagine the nature of your business, you really didn't have the option to have a lot of employees work from home. How did you institute testing, and how did you do so rapidly and in an accurate way so that you could have people actually working in the field?
Well, if you look at our operations, which you're very familiar with, you're probably looking at about 1,500, 2,000 employees out in the operations. And, we educated every employee. I mean, constant communication with supervisors, with managers, employees. One of the things that we first started was taking employees' temperatures every morning, not only at the place of work, but before they got into the transportation vehicles that we bring our employees to work. And everybody understood. Everybody, was in agreement, and we kept everybody working. But the situation, some employees got sick. We would have to cover with our existing employees. Paying overtime, making sure all of our shifts were covered, making sure all of our equipment operators were operating. So it was a challenge all around. And thank God we're seeing the light at the end of the tunnel.
I was going to use that same analogy. Now that we are finally able to see a little bit of light peeking in through the end of that tunnel, how do you see life progressing as you go into your repair season? And how do you mentioned vaccinations? What are you doing to sort of encourage your employees to get vaccinated and sort of return to normal?
Yeah, another good question. We're going to be going into the repairs here probably in about a week and a half. And what we call it's going to be a compressed repair season, because we have to be ready to grind cane again in mid-October. And one of the things that we've done, which I think it was great as far as what the company decided to do, is that we're offering the employees, the vaccine for, at no charge to the employee. We're bringing the clinic that does all of our pre-employment physicals on a weekly basis. We're offering the vaccine to the employees. Totally, it's not mandated. It's something that's voluntary, but we've seen a good turnout of the employees taking it, which I think that's going to help us, keep everybody safe.
What percentage of employees have already been vaccinated?
We're looking probably about 45%, which is a pretty good number when you see the size of our operation.
Yeah, absolutely.
I think it'll increase as employees see that it's the right thing to do. I think the numbers will go up.
Are you thinking about doing anything in particular with the employees who decide they don't want to get the vaccine as the repair season comes in?
No, we're letting everybody make their own decision. We're going to continue with all of our protocols, to make sure that everybody works safely, keep their distance, wear the masks that we provide all of our employees. Like I said, we do the temperature screening every morning, extra sanitation in all of our buses and our vans, in our offices. We have a weekly fumigation schedule that they come in-house, and we make sure that all of our offices are sanitized correctly. So all that has helped a great deal.
How long do you think all these other procedures are gonna persist? I mean, do you all see a lot of them just becoming part of our new normal as we go forward?
I think so, Renee. I think that a lot of this is going to continue, especially when you have so many employees working together, in our distribution center, which is indoors, our refinery, our rice mill. There's such close contact with employees, in the buses that we provide, the vans that we provide, that I think a lot of these practices are going to be the norm.
Yeah, I mean, as you mentioned it earlier about being an essential business, I mean, we do take it for granted how often and how necessary the products that you all make are to us in our lives.
Thank you very much, Renee. We're going to continue to work hard. We'll make this happen. And but there's been many nights where it's hard to go to sleep. worrying about, all the employees here that we have here. It's a big responsibility that we have to make sure that our employees safe and our product is produced in a safe manner.
Yeah, I mean, this was one for the books, and I think you'll be ready for whichever. Hopefully nothing of this magnitude ever comes next, but I think we're all much better prepared for dealing with the unknown and taking things that we used to take for granted and making sure that we appreciate them when they go right every day. Thank you, Johnny, for taking the time to talk to all of us. Appreciate spending time with you, and I'll see you in person real soon.
Yes, sir, Renee. Thank you very much, and thank you to the group.
Thank you.
Long haulers are individuals who have not fully recovered from COVID-19, weeks or even months after first experiencing symptoms. Some long haulers, as you know, have continuous symptoms, while others feel better for a while, and then they relapse with old or new symptoms. If you have an employee who is a long hauler, they may be eligible for FMLA as well as an accommodation under the ADA. Many situations may not be straightforward, and they're going to require careful consideration of various factors. My good friend, shareholder Lisa Berg, has significant expertise advising clients on this complex issue and is here to help us understand the scope of the law and illustrate how to apply coverage.
Thanks, Lori. Today I want to talk to you about long COVID. Long COVID is the constellation of symptoms that some people suffer months after they've had COVID-19. Many of these people refer to themselves as COVID long haulers. Long haulers no longer have live coronavirus running amok in their bodies. If tested, these people would test negative for the coronavirus, but they might be severely debilitated nonetheless. So what exactly is long COVID, and how is it different from the common COVID-19 condition we've become familiar with over the last year? Well, the problem has several names. The National Institutes of Health refers to long-term COVID-19 symptoms as PASC, which stands for Post-Acute Sequela of SARS-CoV-2. More common terms are post-COVID syndrome, long COVID, or long-term COVID. I'll refer to it as long COVID. So what causes some people to have long COVID and not others? Well, we know that people with certain risk factors like high blood pressure, diabetes, obesity are more likely to have a serious bout of COVID-19. There isn't a clear link between these risk factors and long-term problems. In fact, long COVID can happen in people who have mild symptoms. What exactly are these long-term effects of COVID-19? Well, according to the CDC, long-term effects can include continuation of symptoms that happened when a person was first sick, like shortness of breath, cough, fatigue, joint pain, or it can be new symptoms where a patient feels like they've improved and they're recovering, and then a month after being infected, they have worsening chest discomfort, difficulty concentrating, anxiety, depression, muscle pain, rapid heartbeat, and all sorts of symptoms from head to toe that can either persist or develop somewhat newly after they're infected. One woman I spoke with told me for the initial 2 weeks of her infection with COVID-19, she just had cold-like symptoms that lasted for 3 days. She felt fine, and then over the next 4 months, she had debilitating fatigue and could not get out of bed. A man that I interviewed told me that he suffers from brain fog after he was infected with COVID-19, which causes him to have difficulty thinking clearly and remembering things. He'll be at his office and walk into a conference room and then have no idea why he walked into the room. Now, how long can these long-term COVID-19 symptoms last? The answer is unknown. Though it seems like a very long time since the pandemic began, COVID-19 only began wildly in early 2020, and the vast majority of the people who have had the disease are only a year or less into their recovery. Some people are very slow to recover, and it takes them 3 to 6 months to get back to feeling like they have their normal level of energy and that their breathing is improving. Others are 9 or 12 months out from the infection and haven't noticed any improvement. You might be wondering, how common is this problem? Well, last week, Dr. Francis Collins, the director of the National Institutes of Health, told Congress the preliminary reports suggest that as many as 30% of patients who recover from COVID-19 may have some form of a longer health problem. So as of today, That means approximately 9.8 million people could be left with chronic health problems related to COVID-19 infection even after mild COVID symptoms. Look, these are very early studies, and there's still a lot we don't know about COVID-19 and long COVID. So why should this be of interest to you as an employer or HR professional? Some of these long haulers may be your employees and will be coming to you seeking leave or accommodations. Therefore, you need to be prepared to handle these requests. What should you do if an employee comes to you? Come along. Let me talk to you about Barry.
Barry had COVID-19 in January 2021. He was taken to the hospital and was very sick. 2 months later, he recovered and returned to work. But he is making serious mistakes and is written up by his supervisor. He tells his supervisor that he made the mistakes because he can't concentrate at work. His supervisor says Barry must go to HR. At HR, Barry complains that since recovering from COVID, his brain is often foggy and he has trouble concentrating. His body aches all over and he feels really lethargic. He also complains of feeling anxious and extremely sad on some days because he lost many of his close friends during the pandemic and his wife has been out of work for over a year. Barry also shares that some days he's okay, but some days he cannot get out of bed. HR asks, Barry, how can we help you? Barry replies, I would like to be able to take frequent breaks. I want a cot or couch in my office so I can lay down when I'm not feeling well. I also want my assignments emailed to me, and I don't want my coworkers to call me. That way I don't forget things. I also want to take leave whenever those feelings of sadness and anxiety are so bad that it's difficult for me to get out of bed and leave my house. HR turns and picks up the phone and calls counsel.
Okay, so now you saw what happened to Barry. What's our next step? Well, it's time to take out our FMLA and ADA hats. Let's focus on Barry's request for leave first. Do you remember what Barry was seeking? It sounds like he is seeking intermittent leave for those days when he's so depressed and anxious he can't get out of bed and come to work. Put on your FMLA hat. Let's assume that ABC Marble is a covered employer under the FMLA, meaning it has 50 or more employees in each working day during each of 20 or more calendar work weeks in the current or preceding calendar year. Next, we need to determine whether Barry is eligible for FMLA leave. This is a 3-part test. First, has he worked for ABC Marble for at least a year? That's a length of service. Second, has he worked 1,250 hours in the year immediately preceding the leave? That's the hours of service requirement. And third, has he worked at a work site with 50 or more employees within a 75-mile radius? Now, we need to send him an FMLA Notice of Eligibility and Rights and Responsibilities form. The form has several sections. In Section 1, we need to let him know whether he's eligible and whether he meets the 3-part test. Section 2 of the form, we need to let him know if he has to provide a certification to support his request. Here, the company should request a medical certification from the healthcare provider to determine whether Barry has a serious health condition and whether Barry is unable to perform one or more of his essential job functions. The medical certification should be sent to Barry along with the notice of eligibility. Barry has 15 calendar days to return the form. Now, once the medical certification is returned, ABC Marble has 5 days to send the designation notice to him and designate the leave as FMLA if the healthcare provider certified that the employee has a serious health condition. But the analysis doesn't end here. Do you remember what else Barry requested from HR? Barry told the HR director that since he recovered from COVID, his brain is often foggy. He sometimes has trouble concentrating, and his body aches all over, and he feels very lethargic. He wants a couch or a cot to lie on when he feels tired, and he wants instructions given to him in writing. What does that sound like? You got it. That's a request for an accommodation, and that triggers the interactive process with his employer. Time to put on your ADA hat. The interactive process is a prompt, meaningful dialogue between the employer and employee. Generally, an accommodation is any change in the work environment or any change in the way things are customarily done that enables an individual with a disability to enjoy equal employment opportunities. A reasonable accommodation involves the removal of workplace barriers, like physical obstacles, modes of communication, or procedures or rules. So Barry is seeking to modify how others communicate with him and a change in policy, i.e., taking breaks in his office to lie down. Is ABC Marble obligated to provide these accommodations under the ADA? Well, it depends whether he has an ADA-covered disability. Since ABC doesn't know whether his conditions constitute disabilities, it has a right to request medical documentation to establish that Barry has a disability or disabilities under the ADA, meaning a physical or mental impairment that substantially limits a major life activity, and if so, that he needs an accommodation because of these disabilities. Here, it is important to review Barry's job description so we can determine whether these accommodations will enable him to perform his essential job functions. Barry has a duty to cooperate and provide the medical documentation. If he provides documentation confirming that he has an ADA-covered disability and these accommodations are necessary for him to perform his essential job functions, then ABC Marble should decide if providing Barry a couch or a cot in his office and requiring employees to put their requests in writing to him are reasonable accommodations that will enable him to perform his essential job functions, or whether they would pose an undue hardship on the company, meaning a significant difficulty or expense. Lastly, ABC Marble should document this interactive process. Now, if all of this FMLA and ADA terminology sounds foreign to you, do not worry. We will be providing a webinar on this topic where we'll explore these issues in greater detail. So stay tuned, and now back to Lori.
Our next What Keeps You Up at Night segment features shareholder Ingrid Ponce, who spoke with Ashwin Krishnan, Vice President and General Counsel for the Miami Marlins Major League Baseball team. Ingrid met up with Ashwin at where else but the ballpark.
Hi everyone, we're here today with my very good friend Ashwin Krishnan, who I will tell you has one of the coolest jobs you can have as a lawyer. He is the Vice President and General Counsel for the Miami Marlins. And he actually oversees not just this beautiful facility where we're here today, the Lone Depot Park, but also the Roger Dean Chevrolet Stadium in Jupiter, where the minor affiliate plays, as well as a training facility in Dominican Republic. So among Ashwin's many duties, he was responsible for really implementing all the COVID protocols that included contact tracing, testing, and return to the office protocols. So he obviously had a lot on his plate during the last year. And that's on top of all of those HR questions that come up every once in a while. So Ashwin, thank you so much for being with me.
Thanks so much, Ingrid, for having me. It's a pleasure to be here.
So this past year has obviously been very challenging for so many of us, depending on what industry or how it might impact you. Can you tell us about what you saw as one of the biggest challenges that the Marlins had to overcome during the pandemic?
Yeah, I think, immediately as soon as the pandemic hit last March, I think the first thing we wanted to do was check in on our staff, check in on their health, their well-being, just make sure they were okay. At that time, we didn't really know the nature or the duration of this pandemic. I don't think anybody really had a lot of answers, but we wanted them to know we were there for them. If we could help in any way, if their families needed anything, we were there for them. And I think communication has been one of our biggest themes of how we've tried to stay in touch with our staff and just make sure that they knew that we were there for them throughout the pandemic.
So obviously last baseball season was a bit of a different experience for you guys. What have you had to do now going forward to prepare for this season in light of the issues with the pandemic?
Yeah, so going back to last season, obviously we weren't able to have fans in the stands, unfortunately, but we did have a variety of contractual relationships we needed to untangle ourselves from. We had all sorts of sponsorship agreements, vendor agreements, membership agreements, player and staff contracts. And with the pandemic, there was just so much uncertainty about what the season was going to look like. This year, we're very excited to have fans back in the ballpark. The challenges are a bit different now that we have fans in the ballpark. We have a long, full season. You know, the real challenges there are health and safety related. You know, I think we know that our fans, first and foremost, are going to want to know, are we bringing them into a safe environment? Is this going to be a safe place where we're following all the guidance and regulations? And we absolutely are. You know, one of the first things we did as soon as we knew that we could have fans in the ballpark was to meet with the city and the county and say, you know, what do we need to do in order to meet all the ordinances and the guidelines? We looked at the CDC guidance. We had our own medical staff evaluate our different protocols. We actually partnered with Lysol to help us design and enact protocols for the season this year.
Now, the Marlins have always played such an integral part of our community, and in this past year where so many people are suffering, how were you guys able to connect with the community?
Our foundation, the Miami Marlins Foundation, has been integral to all of our efforts and kind of has served as a hub of all of our activities. Some of the things we've done are we've donated over 1 million meals as of last week through our Home Plate Relief Fund. As well as that, we also worked with the city of Miami and Miami-Dade County to actually have a testing site, a COVID testing site on the west parking lots of the ballpark. That has since transitioned to a vaccination site, but again goes to show you know, our willingness to really turn this into a facility that can be used for multi-purposes.
That's really unbelievable what you've been able to do with the community. Let's now talk employment law. So how do you have to change how you have to interact with your employees?
So communication, again, was the key theme of how we dealt with our employees. But we also organized bi-weekly town hall meetings just to get everyone together, to give people a chance to see each other, to talk to each other. We really felt that was a key element of what we were doing. Of course, health and safety was on everyone's mind. So we mailed digital thermometers, we mailed masks, hand sanitizers throughout the year to our staff members, just because, again, we wanted to let them know that that was our foremost concern.
So we've all had lots of sleepless nights over the last year. Can you tell me a little bit about what has kept you up over the last year?
Sure. Literally dealing with COVID has kept us up overnight here at the Marlins. You know, when we started last year, March of last year, we didn't have clarity on whether it'd be a season or not. Once I think we got into July, we started to say, okay, there's going to be a season. You know, what do we need to do? And as part of that, trying to play a season in the middle of the pandemic, there was regular COVID testing of players and coaches, and often we would get the results at 1 a.m., 2 a.m.
Wow.
So you would literally find out results, you know, in the middle of the night. Sometimes whether it's a positive test, an inconclusive test, or the results weren't back in time, you'd then have to make decisions in the middle of the night as to what players need to be isolated, whether the game was going to be played the next day, identifying close contacts, figuring out who needs to be tested again. And those types of decisions that we take for granted in a normal season, you know, when a game is scheduled or what players are going to be available, just became a daily exercise for us of every night getting the results at, you know, the middle of the night, figuring out who needed to be notified, how we needed to adapt. It just became a daily exercise, something we all got used to, but you know, something I certainly never thought would be part of my job as legal counsel for a baseball team. Never thought I'd be up in the middle of the night almost playing doctor, trying to figure out, you know, what these results meant and who needed to be quarantined or what we needed to do for the next day.
You know that baseball's a really big deal in my house, and my family could not wait for opening day. But tell me, how are your feelings about this season?
Very excited for the 21 season. Our team's coming off a playoff appearance last year, had an exciting playoff win over the Cubs.
Absolutely. We watched it.
There you go. It's just a whole different feeling. And I can say firsthand that, you know, from hearing from our players, they feed off the noise, they feed off that energy, they feed off the fan base here. So, you know, having our fans back at home games is going to be big for us, and really excited to, you know, really have Lone Depot Park again serve as a convening point for the community, to welcome all sorts of fans, clients, sponsors, whoever they may be, back to the ballpark and have everyone here cheering our team on. We want to be South Florida's team on and off the field, and you know, that's what we want, and we want the community to really have a chance to experience what we're offering.
That's amazing.
And so I'll add, you know, as a special note for everyone attending this conference, we have a special Marlins discount code.
That's awesome.
We'll send you the details over email, but we're really excited, and we really hope to see you guys all here at the ballpark this year.
Thank you so much, Ashwin, for being with us today. I really cannot thank you enough for giving us the opportunity to be here in this beautiful ballpark, being able to spend some time together. It certainly beats being in the office, whether that's virtual or in person, it doesn't matter. I'd much rather be here at Lone Depot Park, so thank you so much.
Thank you for having me, Ingrid. It's a pleasure to do this, and again, hope to see everyone here at Lone Depot Park soon.
It's time for a litigation chat with shareholders Andy Rodman, Eric Gabriel, and Eric Roth. They will be discussing hot button trends in the employment life cycle. During the recruitment and hiring process, a prevailing trend has been embracing the expansion of diversity and inclusion efforts. We have an entire segment later on in the show that does a deep dive into this important issue. However, for this segment, we wanted to focus specifically on approaches to increase diversity and inclusion during the pre-employment stage. One of those methods is banning the box. This idea has been getting a lot of recent attention as a controversial social justice issue. Advocates of the campaign believe that removing conviction and arrest history questions from job applications and delaying background checks until later in the hiring process provides applicants a more fair chance at employment. Andy, start us off. Give us a sense of where we are in the litigation in this area.
Thanks, Laurie. As you noted, more and more companies are embracing diversity and inclusion as critical components of their operations. We've seen, particularly over the last year with the social justice efforts and unfortunately with the death of George Floyd, it has really raised this issue to the forefront. We've seen, for example, Major League Baseball has been very vocal in this area. They moved the 2021 All-Star Game out of Georgia due to some voting laws that were enacted in Georgia, which are believed to be, by many, to be discriminatory and have a negative impact on minority communities. Of course, not all employers or most employers don't have a voice as loud or as large as Major League Baseball, so many of them are taking it upon themselves to figure out ways how they can increase diversity and inclusion in their own workplace. And one of those methods is through banning the box. And in a nutshell, what that really means is, if you think about it, the good old-fashioned employment application, there'd be a question on the application where it would have a yes or no, both with a box, and it would ask the applicant to check off yes or no, have you ever been convicted of a crime? And that, by some employers, has been used as a screening tool. If you check yes, you've been convicted of a crime, in some instances, employers may not consider you for a job. You won't even get an interview. So there are inequities embedded within that process, because you can imagine if you have, for example, an applicant who 20 years ago had a DUI, who may be a minority applicant who's applying, for example, for an accounting position. You could ask yourself, well, is that DUI 20 years ago really relevant? And if they checked off yes on the box, now all of a sudden they may not even make it to the interview stage. So that is the impetus behind banning the box and removing that inquiry from the employment application altogether. And there's been a movement throughout the country to expand that ban the box process.
So where does it stand here in Florida?
In Florida, we are not a ban the box state. So statewide, employers still can include that inquiry on their employment application. However, there are many municipalities and counties within Florida that have enacted ban the box ordinances. Most of them only apply to the public sector, however, so for private sector employers, it doesn't impact their ability to include the inquiry on the employment application.
So can employers voluntarily adopt a ban the box policy?
Absolutely, and that's what many employers are doing. Back in, I believe it was 2013, Target was one of the first companies to actually ban the box nationwide. And then back in 2016, the Obama administration put forward an effort and had approximately 300 private sector companies sign a petition where they themselves, those 300 or so companies, would ban the box. So employers absolutely can ban the box from their own applications, and many have done so as part of a recruiting tool and to increase diversity within their own workplace. And currently there's about 36 states that have banned the box, and there are about 150 municipalities nationwide that have enacted ban the box legislation. So one day it may be something that is coming to Florida on a more statewide scale, but not quite yet.
So if an employer does ban the box, does that mean that they're abandoning criminal background checks?
No, absolutely not. Those employers that are adopting a ban the box policy, what they would most likely be doing is just moving the criminal background inquiry to a later stage in the application or interview process. So for example, they might, not knowing whether somebody has a criminal background, they'll go through their normal hiring and recruitment process, go through the interview process, and then they would make a conditional offer of employment to the candidate that they believe is best fit for the job. And the conditional offer would be it's conditioned upon you passing a background check. So at that point in time, a background check would be done, and it would be much harder for the employer to then withdraw the offer. And the employer at that point in time will have considered the applicant's merits, the applicant's qualifications for the job, as opposed to having potentially have screened out the applicant much earlier on in the process. So ultimately, the thought is that it leads to a more diverse and inclusive workforce.
Does the EEOC regulate in this area?
The EEOC has had a lot to say about this, not surprisingly. They've come out with guidelines that have basically required employers, whether or not you live in a ban-the-box state, they've required employers to go through an individualized analysis with respect to criminal backgrounds. And what the EEOC wants employers to do is ask themselves the question, okay, this applicant has a criminal background, but when was the conviction? What was the conviction for? Does the conviction have any bearing on this applicant's ability to perform the tasks that their job would entail if we hire them? And give the applicant an opportunity to explain their past. Basically level the playing field and give the applicant a fair shot. The EEOC's position is basically that looking into criminal background may have a disparate impact on the minority community.
Wow, so much insight on this. Andy, thank you.
Well, thank you.
This is a big, big new topic, and we're moving on now to onboarding. A prevalent issue during this stage is the protection of employer intellectual property, and this issue has become even more important in the current work-from-home environment. Eric Gabriel, can you please elaborate on this?
Sure, Lori. Most employers take the steps they need to protect their physical premises or their information technology systems, but not every employer always is aware of what they need to do and what they should do to protect the investment they make in their workforce and in the information and relationships and training that their workforce receives and can develop. In our state of Florida, we've had a statute in effect for about 25 years that makes it a smoother path for an employer to do these things, to put in place the sorts of agreements that would encompass what we're talking about. For example, to identify confidential information or particularly valuable business relationships that are made available to the employees so that after the employee leaves the employment, the employer can still protect its investment in those things. My colleague will talk a little bit about the process that's involved there, but what we encourage employers to do in these circumstances is evaluate each of their key tiers of employees, from the executives at the top to their sales force, to anyone else who might have access to physical information or customer relationships that would be particularly valuable were they threatened by a competing employer after that employee leaves and goes to work for that competing employer. Those time limits for that sort of thing and those sorts of restrictions are not indefinite, but the employer can sit down and should at the beginning of these relationships to try to anticipate what the employer might need to do to protect those things and to put such agreements in place. And you mentioned about the work from home environment. There's a perfect example of how an employer probably could not have anticipated a year or two ago that what the work environment we're all in now. But when an employee has remote access, of course, to the employer's information system, or the employee is in a situation where he or she is working with less supervision, less interaction with the senior management, that employee has even more of an opportunity, if he or she is so inclined, to take advantage of those relationships in a way that the employer would be entitled to protect. So we encourage our clients and employers to evaluate each of these situations in terms of information, customer relationships, and the training they devote to their workforce.
And then that segues us into the final stage, the departure stage, enforcing restrictive covenant agreements. And Eric Roth, Can you talk with us a little bit about what to consider when an employee leaves or when you want to hire someone who's bound by a non-compete or a non-solicitation agreement?
Absolutely. Thank you, lawyer. So non-compete agreements are a little different than the normal contract where you sign an agreement, both parties sign, and if somebody breaches, you just figure you go to court and it's going to be enforced. In Florida and in most states, a non-compete agreement or non-solicitation restrictive covenant agreements are only enforceable if and to the extent they're reasonably necessary to protect the former employer's legitimate business interests. Those would be, as Eric was saying, confidential information, trade secret information, goodwill in the marketplace, specialized or extraordinary training that you might give to an employee, spend a lot of money doing, and customer relationships. So if an employee leaves and you're seeking to enforce one of these restrictive covenant agreements, you need to do an assessment. What is it that they're going to do? If you're going in thinking they can't go to a competitor under any circumstances to do anything, probably a little bit broad and probably an unrealistic expectation. But if you find out that they're, for example, a salesperson going to sell the same product or a competing product to the same customers, that's a red flag. If, for example, it might be an engineer who knows your product formulas or processes or your schematics for the products, that's a red flag. Also, if you provided a lot of specialized training to the person and they're going to do the same job, that might be a red flag because the other employer is seeking to avoid the cost of training and get a jump start because maybe it takes 3, 6, 9 months or some period of time before the person can be productive, but now they're taking your employee, stealing, in essence, your investment so that they can get a jump start. So if those are the things that are happening, then the former employer needs to think about next steps. First thing that we would recommend is do a forensic analysis of their emails and their laptop. Have they taken any information, confidential or otherwise, that belongs to you? Maybe they've downloaded it onto a thumb drive. Maybe they've sent it to themselves by email. Maybe they sent it to their former employer. Maybe there's something on the computer that gives you some clue. If they've done that, you're already one step ahead in enforcing because they're really a bad actor. They're taking things that they shouldn't do because, as Eric explained, they've signed an agreement that says I'm not going to do that. You do need to act quickly. You're going to be seeking injunctive relief, which, and maybe also damages, but injunctive relief is an order from the court where the court says you can't do what you're doing. And that requires you to demonstrate some emergency, some exigency. And if you wait too long, and I'm not talking days or weeks, but if you wait months, the court's going to say, well, it's not that big a deal, you waited this long. So you do need to act with reasonable deliberation, and you need to be prepared to articulate what is it that they're doing that's going to cause you harm. What's your legitimate business interest at risk? Like I said, customer relationships, specialized training, a product formula, etc. Most of the time, we will write a cease and desist letter. Why would we do that? To get the other side's attention. Maybe you can open up a dialogue, and maybe that results in a resolution that you can live with. Well, I often say that a resolution you can live with is better than a litigation, a lawsuit that you think is really great, because once you're into litigation, now a judge is going to decide, or a jury, somebody other than you is going to decide your fate. You lose control. Plus, resolving it helps with keep down the costs and the time and expense of litigation, not to mention the uncertainty. That's not always the case because sometimes you need to act quickly because the person is really already stealing your customers or has taken, because you've done the forensic examination, has taken your information. So if you go to court, you're going to be seeking injunctive relief, and that's usually a several-month process before it's over. Or one way or the other, the judge will make a ruling, a preliminary ruling, which usually leads to a resolution because the parties know which way the judge is thinking. Now, that's if you're trying to enforce. What if you want to take somebody and employ somebody who's got a non-compete or restrictive covenant agreement? And I always counsel people to say, look, you may face litigation. These agreements are enforceable in Florida and in many other states. So be sure that the person you're seeking to hire is worth it. Be sure that they're a really strong player, not just somebody that would be convenient to have on your team, but somebody who's going to be a really strong player. And then find a job or a position there that's not going to jeopardize the other employer's legitimate business interests. So, for example, if you're hiring a sales representative, have them call on new customers. You're hiring them not because they have strong customer relationships that you want to take from your competitor, but because they're very skilled at selling. That would be a reason that you could, so if they sell in Miami-Dade County, give them a territory in Broward County as one example. If they are an engineer, have them work on a different type of product so that they're not necessarily going to use the information that they had. So be mindful of that process. So there is a way to do it. You need to be thoughtful about it. It's helpful to talk it through with the other employee, with the prospective employee, so that you understand what their limits are and what they did for the former employer, and hopefully you can work through those issues.
And that's one area that hasn't changed post-pandemic.
Correct. There's still a lot of litigation going on. People are changing jobs, and it's important to be mindful of this topic.
Well, you are the top in your field with this litigation in every level of employment and the employment process. We thank you for this litigation chat, gentlemen, Andy, Eric, and Eric, and we will continue. In our third What Keeps You Up at Night, shareholder Janet McHenry speaks with Qualenta Kivett, Executive Vice President and Chief People and Talent Officer at Tampa General Hospital. As one of the largest hospitals in the country, Tampa General is a 1,007-bed nonprofit academic medical center lauded for delivering world-class care. The hospital has been named Tampa Bay's top hospital by U.S. News and World Report for 5 consecutive years and attained magnet recognition, the highest national honor in professional nursing practice, for 4 consecutive years. With more than 8,000 team members, the hospital system is one of the region's largest employers. Janet's been working with Tampa General for 27 years and recently assisted Stearns Weaver Miller in establishing a dedicated annual nursing scholarship. And working in a hospital, I'm sure there are so many obstacles that Qualenta had to overcome this year. Let's hear from her firsthand.
Well, thank you again so much for agreeing to be part of our program. Now, given our topic, what keeps HR executives up at night, particularly during a pandemic, can you describe a little bit about the major challenges that you or the hospital faced during this past year and how you were able to overcome them?
One of the things that is difficult in healthcare is really finding people, finding the right skills. And I don't know that that's new for us, but it was certainly something that our attention was drawn to during the pandemic. When you think about healthcare, you think of doctors and nurses, but what people don't realize is that there is every skill set that you need it can be found in a hospital. So the people that clean the rooms, I mean, those are essential workers in our environment. The people that are greeting you at the front and guiding you through a hospital, those are essential. So we have so many people. It doesn't take an education at the college level or even post-college. It can be a certificate, it can be a license. That has really brought our attention back to our staffing and how we can do it differently. Another thing that we've learned during this time is how do we get that message out there, right? And how do we look at scheduling differently? One of the things that healthcare has always been hesitant to do, at least seemingly so, is remote work and thinking about schedules a little bit different. And we've been challenged with that during this time.
What are your predictions for changes in HR for the coming year as a result of what you have learned during the pandemic for the hospital and perhaps for other employers as well?
I've seen a lot of collaboration. I hope that continues. I think it's better for our communities. We've also given more community access points. So we have telehealth that we're offering more often. We have a community helpline. So I really see us moving more and more, and it was part of our focus and growth, but maybe just accelerated a bit. But we are moving more into the communities and into partnerships on how we can look at things different. You don't have to be in healthcare to need a healthcare partner.
Do you see your role or even HR's role changing as a result of what happened this past year?
So shameless plug, HR is a strategic partner, and those industries that have known that, I think we saw the best performance and support from our HR partners during this time. The industries that have evolved or businesses that have evolved into understanding that, I think have learned a lot. So to answer your question, what's changing in HR? I would say nothing. If you think about HR, we touch every piece of a person from their experience before they come through the door and their experience as they're exiting. I think our goal is how do we keep that hands-on approach And that's probably been one of the challenges. How do we keep the hands-on approach and make people feel welcomed and part of the family as they continue to onboard during this time?
And so how have you done that?
We've listened. I think if you hear nothing else during my words as I'm sharing is listening to our team members. We're still offering orientation. It just looks a little bit different. We meet them in the front. We give them their bag of goodies, and then the team members go to their floor and they're instantly welcomed on their floor. So we're doing a mix of in-person and hands-on, and a lot of the hands-on is happening in the unit. I don't think that's a bad thing. It's certainly a great welcome for the team member, but we will continue to evolve. And I don't think that we've seen everything that we want to see just yet. But I think as long as we continue to listen to our team members and evolve and stay agile, we'll be able to adjust.
Many of our clients are smaller to mid-size employers. Do you have any recommendations for those employers? And how can TGH's strategies benefit those employers?
There are two pieces of advice that I would provide. One of them is listen to your team members, your employees. That has really been helpful for us during this time. We've been able to offer community support, helplines. But in addition to that, we've also been able to support our team members in different ways. When schools went remote, we actually were able to provide computers so that education could continue at home. Those are things that we really look for recommendations. We have a direct line into our executive team that people are free to reach out. They can share with their leaders, and it's really an environment that leads to innovation. The second one is collaboration. Tampa, the chamber does offer some great opportunities for collaboration. I would say the other thing is reach out. I think everyone during this time is looking for partnership. We're looking for learning. And I don't think that the size of the organization should be intimidating. We're here as a partner to the community. So absolutely collaborate, listen to our team members. I think we're all learning. And that's really, for me, the takeaway.
I have one last question for you, and that is, if you go forward in 3 or 4 years from now, maybe even 5 years from now, and looking back to this past year, what will you remember most about the pandemic?
Resilience. The resilience of people in general. But when I think about it in the healthcare environment, we have people that are here caring for patients. We have people that are working from home. We have people that are bringing their best to work and also taking their best to their family. And that to me is so refreshing. It's exciting, it's invigorating, because those people have not lost what drives them. And that's really their dedication to our patients, their dedications to the team members, and their dedication to our mission and our vision.
It really sounds exciting, and I want to thank you again for participating with me in this interview and being able to share this information with all of our other people who will be listening in onto this program. Thank you again.
Thank you.
Over the last 14 months, the pandemic forced employers to play catch up in a rush to implement the never-ending laws and guidance that federal agencies issued covering employees, payroll taxes, and benefits. During this time, the U.S. Department of Labor also released several key pieces of important non-COVID-19 related guidance. Employers now need to focus on compliance with these new directives, including the DOL hot topics of cybersecurity for employee benefit plans and handling missing participants, which we'll cover today. Shareholders Sharon Quinn Dixon and Andy McLaughlin are here to discuss these topics and much more. Both Sharon and Andy have their LLM in taxation, and Sharon is board certified by the Florida Bar in tax law, recognizing her as an expert in the field. Sharon and Andy, take it away.
Thank you, Lori. It has been an extremely busy year for benefits professionals and our clients. But as we leave the busyness of the pandemic of the last year behind us and slide into the second half of 2021, we have to focus on the federal regulators' guidance that has come out this year, because we think that this is going to be the focus of their investigations in the next few years of employee benefit plans.
I agree. I think the good starting point is cybersecurity. We've seen some recent guidance from the DOL on this area, but as most plans that for a long time have been aware that they have a fiduciary duty not only to protect employee assets, but they also need to protect participant data and make sure that participant data is secure. And so it's been a hot topic, but we haven't seen a lot of regulatory guidance. So what we've had is the service providers providing their best practice and their webinars and their suggestions. But recently, the DOL has finally chimed in and provided some much needed guidance. Sharon, why don't you share what they've provided?
Sure. The most important aspect of the DOL guidance was this idea that employers need to be aware that they have an obligation to eliminate the risk of cybersecurity attacks on their plans. And the DOL did this in a three-pronged approach in their guidance. The first aspect of it was aimed primarily at service providers. Those are the outside vendors, the record keepers, the custodians that have your participant information and data. So they said to the service providers, you need to have well-documented and formal cybersecurity procedures. And they're supposed to cover it from the most basic concepts of like multi-factor authentication and encryption to having third-party audits of their procedures on a regular basis and outline what they're going to do if there is some cybersecurity incident. The Department of Labor aimed this guidance at the service providers, but in reality, it's going to be the employer's responsibility to make sure that the service providers follow this guidance because the employer ultimately is responsible for the operation of its plan. So we can expect that the Department of Labor is going to be pressing employers in the future to know what they have done to make sure that their service providers are adequately taking care of the cybersecurity risk. One of the best ways to document that an employer has done that is in the contract with the service provider. Andy, what did the Department of Labor say about the contract provisions?
They've provided kind of tips for employers and plan administrators to best select service providers. And they talk about, as the first thing they say is that you should not deal with a service provider that doesn't have a cybersecurity plan. And then they go a step further and provide a list of things they think should be in your contract. For example, they say you should have provisions dealing with what steps the service provider will do to take care of your data. You should have in your contract how they'll respond to incidents. And I think this, how they'll respond to incidents, is really important. You might want to have deadlines, how many days before they notify you? Is it 24 hours? Is it 48 hours? And have a set. So if there is a breach, the employer gets notice right away. And lastly, they talk about you should require your service providers to have insurance. Now, while a data breach can be very expensive and there may not be adequate insurance available for particularly very large plans, it's important that you at least address this issue and get the best you can from your service provider.
Absolutely. In the last few years, we've seen a lot of service providers attempt to have some sort of cybersecurity protection in their contracts, but we were always pushing for more protection for the employer. And this way, with this Department of Labor guidance, it'll help in our push efforts. And the Department of Labor didn't stop, though, in its guidance with service providers and employers. They also issued tips for participants. They issued tips that those of us who are paying attention to cybersecurity risks have heard in recent years, but they include things like choose a strong password, change your password on a regular basis, monitor your account, don't just set it once and then walk away from it. Oh, and how about avoiding public Wi-Fi like at Starbucks and McDonald's and the airport, even though they're so terribly convenient? And a final important point is, don't forget to tell the plan administrator your home address, a snail mail address, because if something goes wrong, they may well have to contact you at the snail mail address. So I think that the Department of Labor is providing these tips to participants, but employers would be well advised to educate their participants on these points and also enlist the aid of the service providers to do that.
Well, I think this is cybersecurity is much like any other fiduciary duty. Your duty to choose prudent investments. It's something that needs to be monitored on a consistent and constant basis. Cybersecurity is an area that is constantly evolving. And so I think we don't know what the next attack will be or what the next big threat in cybersecurity will be, but plans need to be thinking about this and proactively taking steps so that they're ready.
Well, one thing is for sure, the area of cybersecurity for employee benefits is not just a one and done proposition. As you noted, Andy, it's going to require some vigilance on the part of plan administrators on a regular basis. So I think to summarize the Department of Labor guidance, there's really 4 areas. Employers, you need to be aware that this is your responsibility. And second, you need to work with your service providers. You need to have specific contract provisions aimed at guaranteeing that the service provider is doing everything it can to protect that data. Third, you need to be monitoring that service provider on a regular basis. Make the cybersecurity evaluation part of the plan review, like everyone typically does at least annually, reviewing investments and administration. Cybersecurity should be part of that. And finally, educate your participants. In many cases, they might be a first line of defense from the loss of that participant's account, or worse, to the rest of the plan. But let's shift now to some other recent DOL guidance as well. This is in the area of missing participants. Andy, who or what are missing participants?
As the name implies, missing participants, those are the participants that have a balance in the plan but cannot be located anymore. Most of these are the former employees or beneficiaries. I think most employers have a good idea where their current employees are, so it's not until after they leave employment that they become missing. A lot of the missing participants, they generally have the smaller balance in your plan, though every now and then we have found a missing participant who may have several thousand or even $10,000 in account balance that they can't be located. There's a lot of reasons why these participants become missing, but I think the biggest reason is that they're individuals who you have stale data. They left employment with you 5 years ago, and they've moved addresses, they've changed phone numbers, and you just haven't kept in touch.
So Andy, what are they really talking about with the census data?
Well, I think the Department of Labor was very disappointed in some of their investigations at the state of the data they were seeing on participants. They were finding things like certain plans had an extremely large number of Jane Does or John Does listed as beneficiaries. They had missing addresses. They had missing phone numbers. They had phone numbers without area codes. And so it was very clear that this data was just not correct to anybody looking at it. Look at your data on your employees and your participants and update it, and make sure if there's easy, simple fixes where there's clear and obvious problems, you're fixing it. They basically want you to take actions now while you can.
Well, and one of the actions that you can take now is having effective and clear communications with what might be a missing participant. For example, in my experience, the record keeper or the plan will be sending some sort of mail, snail mail, to the participant's last address. Even if they have the correct address, it might be that the participant ignores it because they perceive it as junk mail or some fishing expedition, some sales. And so it should be clearly marked, for example, with the employer's name or some sort of tie to that employer that piques something in the employee to actually open that piece of correspondence and find out what's involved with it.
Well, then after that, the DOL is focused on that if you can't find the participant, you can't just stop. They didn't respond to my letter. The DOL is not happy with that response. They really want employers to take affirmative steps to find participants. And these affirmative steps, they can be very simple from a simple Google search. I think the DOL has seen that how many of the supposed missing participants could be found just by Googling the person. But they also recommend that there's other services. Maybe you need to use a commercial locator service. Maybe you look at death registries. But they really want the plan to have procedures and protocols so that they can search for these individuals and find them. Because in many cases, a missing participant really isn't that missing. And I think that leads to kind of the last point is the best thing for a plan is to not have missing participants. So how could you avoid this issue to begin with?
Yeah, not have the missing participant in the first place. And actually, most employee benefit plans have a procedure built right into the plan where they can pay out the person as soon as they walk out the door and not wait for that person to come and claim their money. There's an automatic cash out procedure in most plans up to $5,000, and most of these account balances are well under $5,000. So if the plans and the service providers would just use the procedures that are built in there right now and pay out people as soon as they leave, they wouldn't have this whole cadre of missing participants for the Department of Labor to get excited about, and that will form a big problem in the future. So they just need to take advantage of the tools they already have. You can count on having to respond to the Department of Labor, if chosen for an investigation, as to exactly how you're going to find your missing participants. And speaking of Department of Labor checklists, we can expect that the future investigations, in addition to our missing participant information and going back to our cybersecurity issues, they're going to have whole checklists for cybersecurity risk minimization. And employers need to be prepared to address how they're going to deal with this if the Department of Labor is asking for their best procedures. So please, we encourage employers to use this recent Department of Labor guidance as a roadmap to the actions they need to take now before they get that knock on the door from the Department of Labor investigating.
In our next What Keeps You Up at Night, shareholder Bob Turk talks with Annie Borges, the Director of Human Resources for Fisher Island Club, a private, membership-only club with a private beach, luxury hotel, golf course, tennis courts, a variety of casual and formal dining venues, full-service spa, salon, fitness center, so much more. Fisher Island Club has a year-round staff of more than 400 employees and additional employees during the winter season. Well, Bob had the really tough job. He got to meet up with Annie on beautiful Fisher Island.
Well, hi, Annie.
Hi, Bob.
Thanks for joining me today.
Of course, a pleasure.
So we've known each other a long time.
We have.
And I think I met you first when you were at the Doral Resort, which is the golf and spa resort.
Right.
And then you moved, I think in 2008, over to the Clevelander Hotel and the Essex Hotel in South Beach.
Right.
And then you joined Fisher Island Club in 2015.
Yes.
And how many employees do you have here?
We have about 350 average employees.
And that includes in what areas?
We have mainly, obviously, food and beverage is our main area. We have 7 restaurants here, so primarily food and beverage, but we have 15 villas, so we have hotel employees. We have an island market, which is a full capacity market. And so it's a little bit of everything. We have administrative employees as well.
So with all of that, 15 months ago, COVID hit.
Yes.
What's been the challenges that you've had since then?
You know, I think the number one challenge I think many people face is the fact that there was no lesson plan. There were no guidebooks. There was no one telling you what to do. You had a mandate come out and all of a sudden you had to sort of scramble and see how that mandate fit into your world, and you had to roll it out to the employees, making sure that everyone understood them and then obviously complied with them. So it's been a challenge keeping up with the mandates, because as if you recall, in the beginning it was changing all the time. So that was probably the biggest challenge, and making sure the information was current, and it was something that the employees were able to accomplish on a day-to-day basis.
And when we talk about challenges, so what have you done to address those challenges?
The situation we had here during COVID was that our employees were considered essential workers. So we never closed. During the whole pandemic, we did not close, we did not stop operations. So the challenge was having employees in a safe environment where they felt safe coming to work, offering them hours wherever we had hours available for them. The club did pay for employees, even though, let's say, for example, they only worked 16 hours, they were actually paid for 32. We tried to keep them safe. We offered testing early on. If you recall, when I called you and I said, Bob, we were going to do testing. So early on, that was just some of the things that we had to really step up our game to make sure that our employees were safe, they were compensated, so they had a place to come to work and felt good about what they were doing.
And have you had to work with, I know it's the club and then you have the homeowners association.
Correct.
So,
yeah, and going back to the challenges, right? It was the fact of when we rolled out anything or communicated anything, how was it going to affect all these entities? And so yes, we have the homeowners, we have people that rent here on the island, we have employees. So there were certainly different stakeholders, but at the end of the day, the common goal was always, staying healthy, staying safe, and managing the process.
And so how has your role changed since COVID?
I've been the COVID police, Bob. It's COVID compliance. I've shifted from just the HR director in that role, but really COVID compliance. It's been what we do every day, all day.
And then just in terms of when you say that you're being COVID police or COVID all the time, what are you doing on the island with your employees? You talked about testing. Are you testing on the island? Or?
We are testing on the island twice a week. We still test. We started that back mid last year. We've done over 7,000 tests to date. So we are offering a financial incentive for our employees to be vaccinated. So that's hopefully will get us to where we would have more employees being vaccinated. We're trying to see if we can get vaccines here on the island. So obviously our goal is to have all of those employees that want to be vaccinated and can be vaccinated to give them the ability to do so. So it's definitely, we're on the right track to have them vaccinated.
So as we've talked about COVID, with everything that's gone on the past year, what's kept you up at night as an HR director?
Everything that needs to get done, everything that needs to be communicated, keeping everybody healthy and safe, it's really been our goal and our objective. So whatever it takes, and I think that has proven to be very successful for us because we have been able to minimize the amount of exposure here and mitigate any kind of serious health situations.
And I know as we're coming out of the pandemic, the entire hospitality industry, at least in South Florida, the challenge is to find employees now. Mm-hmm. Have you had that same challenge, and how are you addressing that?
It's been very challenging. It's been very challenging because we went from nothing to full gear. And so the employees we needed to get ready for season, we're having a difficult time finding. And I think there's different circumstances that are pulling at those challenges.
Well, no, you're not alone in that because
Yes.
all the hotels, all hospitality in South Florida has that same challenge.
Absolutely. We all talk to each other and we know that it's not necessarily just about pay.
So it's one of the last questions I have. How has COVID changed your life?
Yes, it has changed my life, and I think that anybody who is asked the same question would say it's changed their life. And I think in many ways we had to really think outside the box, be different people. We became chameleons, right? We always are, but I think it just emphasized how different we had to do things and how we had to manage our business, handle people. And so I think for me, it has changed my life. I certainly am more appreciative of my life and the blessings that life has. So I try to live more in the moment than I did in the past. So definitely, I think it has definitely changed me for the better, for the better.
Wendy, let me thank you for joining me today.
No, thank
I
you,
really
Bob.
appreciate your comments.
Thank you.
Social justice and diversity issues have been brought to the forefront this year, and many employers are grappling with what they can do to make the workplace, the community, and the world a better place. I'm here with attorneys Jean Stearns and Janaea Reed to discuss what their law firm has done in this area and what businesses should be thinking about regarding their diversity and social justice initiatives. Jean is a founding shareholder and current chairman of Stearns Weaver Miller's board of directors. He also heads the firm's litigation department. After serving in a number of governmental advisory roles early in his career, Jean has remained actively involved in a host of public policy issues on both the state and federal level. Janaea is also a seasoned litigator and shareholder of the firm. She has extensive experience representing clients in high-stakes litigation at the trial and appellate levels. Janaea currently chairs the firm's diversity committee, and she's also one of 6 members of a leadership council for a new Black Lawyers Forum established by Meritas, which is a global alliance of market-leading law firms, including Stearns Weaver Miller. We all know after the death of George Floyd, employers are really looking to the issues of diversity and inclusion more than ever. What are some of the ways, Janaea, that companies can facilitate these conversations?
I think really, Lori, one of the most important things is intentionality and making sure that these conversations aren't just happening, spontaneously, that we're actually creating active spaces for these conversations to happen. So one of the things that we've been focused on doing is really making sure that there's spaces for people to have their voices heard, and also really acknowledging the discomfort. I think that this topic has really been taboo for a long time.
Jean, that takes leadership. It really does. I mean, it just isn't willy-nilly, like you say, and you don't want it to be uncomfortable. I mean, how do leadership and organizational culture of an employer, how does that play into this?
Well, obviously leadership plays a critical role. Janaea, for example, has a leadership role in our firm. Many others who in our firm have extraordinarily diverse backgrounds. The idea is that if you can surround yourself with people who have different life experiences than you have, if you listen to what they have to say, and as Janaea says, create spaces and opportunities for people to be able to speak, to compel other people to listen, then it creates an environment that I think works for us to better understand each other. I mean, what Janaea has taught all of us and what her committee has taught all of us and what we have learned from the spaces she has created is that affirmatively addressing issues is far more important than thinking you don't need to, because we're good people. We're not good enough, and that's the fact, is that you have to affirmatively go do something more than just think, it's not my problem, I'm an okay person. And that's something I think we've learned through this process. And I would hesitate to say it's a result of leadership. I think it's more a function of people willing to listen when people want to be heard. And what George Floyd has done is compelled a lot of people to talk who didn't before. And now the question is leadership willing to listen? And our firm people are willing to listen. And I think that's really probably an important part of the difference.
You can see it in the attorneys that are gathered in this special today. You really can. A beautiful diversity and a willingness to listen and talk. What initiatives have your firm specifically put in place now, Janaea?
So one of the things that we started initially with was to have, small focus groups. So the YWCA has a 21-day challenge, and we put together a small group within the firm to participate in that challenge. And I think one of the things that we were able to do with that is by starting small, we picked people who had been at the firm for a long time, really know our culture, really know all of the things that are important to us. And then we can kind of take those things and tailor them to our organization and the things that we want to do in terms of creating space for the conversations. So that's what we really did, and that launched the Equity and Justice Project that we have at Stearns Weaver Miller, where we're focused on education. We have weekly emails about topics on diversity, equity, inclusion. We also have Friday forums where we talk openly about the different things that are going on in the country, what's led to them, all of those kinds of things, and having those conversations and being able to openly talk about them without fear of saying something wrong. I think that's really what we've been focused on, trying to make sure that no one feels like they can say something wrong. We're all learning and growing together.
And the name is so solid, Janaea, Equity and Justice Project. Tell us more about that. What are the specific features of this?
Sure. So we have education is really a component, education and reflection. I think making sure that everyone understands the issues and is talking about them openly, that's really the first component. But we didn't really want to just focus on conversations. We really wanted to also shift to engagement and making sure that our firm has a long-standing history of having engagement with the community and supporting community initiatives. And so making sure that we are actively involved in those spaces and continuing to highlight the involvement that we already had was another piece of the engagement that we wanted to have through the Equity and Justice Project. And then we also have our diversity committee, which is active and meeting and working on a strategic plan as well.
Nice. So this is important for you all in every realm of your lives. I mean, this is important in the courtroom, for your employers, for your clients, but this is part of your culture now for you all.
It is, but I got to tell you, I've said this frequently, but when I was an undergraduate, I went into a history class and a professor had a picture frame up. And everybody goes, what is that about? And he said, I'm going to tell you something that you might not have thought of. This is my frame of reference, this is your frame of reference. And if you understand the world, the history of the world, the history of civilization, try as much as you can to see the other side of the frame and see how other people live, how they think, because their frame of reference is going to dictate what they hear and learn and what they gain from being in the same place at the same time, because all of us are going to walk out of here with a different impression of what happened.
You mentioned this new group. You are now part of this Meritas Black Lawyers Forum. Why is that an important step for the firm?
Sure. Black attorneys have been largely underrepresented in law firms. The numbers tell us that in law firms, black attorneys are about 5%. And if you look at the partnership ranks, it's even lower. And so one of the things that the Meritas Black Lawyers Forum gives an opportunity for us to do is to increase diversity within the legal profession, and also to really identify and address some of the challenges, unique challenges that black attorneys face.
And how do you feel about all this?
Well, I think it's honestly, I have mixed feelings. First of all, I'm terrific that we're doing it. I'm proud of what we're doing. But at the same time, I'm sad that we have to. I am never comfortable being surrounded by people just like me. I've always in my lifetime been comfortable with people who aren't like me. And to me, the greatness of America has been what its promise is the diversity that is offered in this community.
How do you take this to your clients now, the employers?
Well, our clients, we represent very good people, honestly. We represent employers for the most part who I'm proud to represent, who are as concerned about the problem as we are. So we have not seen the slightest impediment in this work in dealing with our client base.
And Janelle, what do you think are the key takeaways now that you can share with everyone listening?
Sure. So I think that, Jean has been modest about the impact of leadership, but it really does start at the top. It's important to have leadership that is committed to the issues of diversity and inclusion and creating a workplace where everyone is included and feels welcome. Another thing that I would say is really know your organization. So for us, as I talked about with the Equity and Justice Project, we really knew what, how we interact. We enjoy talking over breakfast. We enjoy talking over lunch. So we felt comfortable coming into the spaces that we've created to have conversations and to really feel comfortable talking with one another. So you really have to know your organization and start where you are. The other thing that I would say is really just also making sure that everyone understands that this is collective work. So it's not just the diversity committee. It's not just, the people that we've assembled. It's collective work. We're all learning together.
Very key. You don't want this to be just one little committee or a chore for anybody.
To
you
the
want
contrary,
it to be the culture.
It's a life's work, and it always needs to be a life's work. And frankly, we learn more about ourselves. It's not just helping other people. The reality is when you do something that is important to do that you didn't know was important, you're growing yourself. And that's what I think we've been able to achieve. And frankly, I think most of our clients feel the same way. I don't know about you, Janaea, but I think our client group is 100% supportive of what we do.
Absolutely. We have wonderful clients. And, I think they really look to us from a leadership perspective of expecting that we are going to take a leadership role in the community and really embracing that.
And what can I learn from everyone around me?
The truth is, you gain so much when you're doing the kinds of things that we're engaged in this community and in all the communities in which our offices are located. It's really an exceptional group of people.
Well, you have been huge role models for diversity and inclusion, and you are leading the way, and it means a lot for your employees and your clients.
Thank you, Laurie.
Jean Stearns, Janaea Reed, thanks for all you do. If you love gorgeous cars, you're going to love this next segment. Shareholder Lisa Berg speaks with Mia Martin, Assistant General Counsel and Director of HR for Braman Management Association, in our fifth What Keeps You Up at Night chat. Lisa has been working with Braman for 18 years. Family owned and operated for over 40 years. The Braman auto dealerships, including Rolls-Royce, BMW, and Hyundai, have some of the largest luxury showrooms in Florida. Let's see what drives Mia.
I'm here today with Mia Martin, Assistant General Counsel and Director of Human Resources for Braman Management Association. I've represented Braman for 18 years, and I've had the pleasure of working with you for almost 6 years now. Thank you so much for joining me today. So what role does Braman Management play with respect to the different dealerships?
The Braman organization has 7 auto dealership campuses here in South Florida and 3 in Colorado. Braman Management Association is the management and advisory arm of the Braman organization. So Braman Management Association provides legal, financial, and operational oversight to all of the dealerships. Now, in my role as employment counsel and HR director, I oversee all employment-related litigation, and I ensure that all of the dealerships are in compliance with all applicable federal, state, and local employment laws. So all of the dealerships are independent companies, and they have their own management teams and their own HR personnel. And right now we have roughly about 2,000 employees organization-wide. So on a daily basis, I interface with dealership management and the HR personnel, providing advice and counsel on a variety of employment issues.
So let's switch gears for a moment. How has the pandemic affected Braman?
So most people may not realize this, but as an auto dealership, we were deemed an essential business under the local executive orders. And that means that we were open the entire pandemic. And as an essential business, we had to be here for our clients to service their vehicles, if they needed new cars, obviously to sell them new cars, and repair any damages, for example, if they were in accidents. So we really required our entire workforce to be in. So for my first priority, it was really to make sure that employees felt safe.
I imagine that was not an easy task in a pandemic. Many of our clients easily were able to shift their employees to remote work, but Braman has so many customer-facing employees. How did you handle those challenges?
Well, first off, even though we needed everyone to come in, anyone who did not feel safe, we accommodated either with a leave of absence, and where possible, we allowed folks to work remotely. So that was the first thing. We also, from the outset, we closely followed and monitored the guidance of public health officials, of course, including the CDC. We also installed protective shields at most of the workstations. Another thing we did is we implemented policies designed at reducing the exposure and the spread of COVID-19 in the workplace. And those included work exclusions and mandatory testing for employees that were sick. So we also implemented a contact tracing program to identify and notify folks who may have been exposed to COVID-19.
We have a huge audience of HR professionals that are watching. So what advice can you impart to them on your biggest challenge and how you dealt with it?
Our biggest challenges came early in the pandemic. And one of the challenges we had, one of the biggest challenges we faced was how to deal with an employee who had tested positive. The Miami-Dade County order that addressed that subject was not very clear and was really open to interpretation. So at that time, we took a very conservative approach, the safest approach, at least we thought, and we were basically shutting down entire departments when an employee tested positive for COVID. So the thing that was most helpful for me in dealing with the pandemic generally was to really stay on top of the CDC guidance and guidance from other health authorities, and that allowed us to make informed decisions and implement appropriate workplace policies very quickly, which we constantly changed to comply with constantly updated, guidance. And of course, we received invaluable guidance from our outside counsel, as you know.
Of course.
So in the face of any new challenge, my advice would simply be to stay calm, educate yourself as much as possible, be adaptable, and of course have excellent outside counsel to assist you.
Has your business model changed in any way on how you serve your customers?
So the nature of our business, primarily selling cars and servicing cars, involves a great deal of in-person customer interaction. So having implemented some of the safety measures that I just mentioned allowed us to continue to safely provide that high-quality in-person service that we so pride ourselves on here at Braman. But of course, we had customers that understandably did not want to come in. So we also implemented a number of contactless ways to serve our customers. So at many of our dealerships, you can get your car serviced, or you can even purchase a car without leaving the comfort of your home.
That's great. And what are you most proud of?
the fact that we were able to remain open the entire time and safely operate with nearly a full complement of employees, and we were actually able to thrive. I am so proud of the teamwork and perseverance of my Bremen management colleagues, of dealership management, and of course the employees. It took everyone pulling together to make it work.
Mia, it's really impressive what you and Bremen management have accomplished during this pandemic. And personally, I can't thank you enough for your time and advice.
2021 has been flying by. It's hard to believe that as of June 1st, it is hurricane season once again. Let's hear from one of my longtime friends, Brian Norcross, hurricane specialist at WPLG Channel 10 in Miami, and he is the author of My Hurricane Andrew Story, the story behind the preparation, the terror, the resilience, and the renowned TV coverage of the great hurricane of 1992. Brian, how's this year's hurricane season looking?
Hi, everybody. Thanks for having me here today, and thanks to Lori for calling me up to talk about hurricane season 2021 and hurricanes in Florida in general. First of all, in any one year, we have a better than 50-50 chance, a 58% chance, historically speaking, of having a hurricane strike the state of Florida, with a strike being counted as coming within 50 miles of the coast. So bottom line is we have to expect a hurricane to affect Florida every year. But what makes our hurricane season busy? Well, it turns out we have to look in both the Atlantic and the Pacific. First of all, in the Atlantic, if the water out there in the tropical Atlantic is warm, of course, that means more fuel for hurricanes. They get stronger in general, and more of them form. Now, in the Pacific, we look for cool water for a busy season because cool water in the tropical Pacific is called a La Nina, and that produces conducive winds for hurricane development over the Atlantic. So that's what we're going to look for to see if this season might be busy. Well, first of all, in the Atlantic, so far, the tropical Atlantic is fairly cool. Good news there, but the subtropical Atlantic, and this is up where Hurricane Andrew tracked and other storms tracked when they get near the coast, that's quite warm. So the net of the Atlantic is slightly conducive to a somewhat busy season. In the Pacific right now, in the box where we look out here in the tropical Pacific, it's somewhat cool, but not super cool. So we call this technically a neutral condition, and we can have busy seasons or non-busy seasons when it's neutral, so we'll keep that in mind. When the agencies across the world crunch all these numbers, they come up with a consensus of 18 named storms. These are the average of all these different agencies, with the average or the normal season being 14, but that's averaged over the 90s to the 2010s. And back in the 90s, we didn't have the technology we have now. So the numbers, just because of technology, have increased a little bit. So the real average is somewhere in the 15 or 16 range. So bottom line, we'll call it somewhat above average. We call this a low confidence forecast because it's a spring forecast, and all forecasts this time of year are low confidence because those water temperatures can still change. But the bottom line is we do not expect a season like 2020. The water in the Pacific is not as cool. The water in the Atlantic at this point is not as warm. So that's a little bit of good news. Hope to see you on Twitter, hurricaneintel.com, or feel free to get in touch at bnorcross@wplge.com. Have a good day.
Thank you, Brian. And you heard it right here. With forecasters predicting an above-average season, it's important for employers to do some pre-storm planning and to understand their legal obligations, including when they need to pay their employees. I'm joined now by shareholder Glenn Ristman with important issues to consider now through November 30th when this hurricane season comes to a close.
Thank you, Lori. Now that Brian has shared his thoughts on this year's hurricane season, I'd like to share my top 5 tips for employers to consider in the event of a hurricane or other workplace emergency. Tip number 1, plan, plan, plan. Can your business operate without computers, copiers, files, electricity, water, or internet? Do you need to order supplies like batteries, bottled water, waterproof storage boxes, plastic sheeting, garbage bags, and duct tape? Should you restock employees already working from home with office supplies prior to the storm? And provide your office regulars with supplies to help them work from home if necessary. Many of your employees probably have company property in their homes, such as laptops, printers, modems, and files. Make sure employees take time to secure company property and safeguard paper or electronic files that are sensitive. Tip number 2, communications. How will you stay in touch with your employees and customers in the storm's aftermath? Make sure to update your contact information for current employees, clients, customers, and vendors. Print copies of contacts in case you cannot access these electronically after the storm. Post company-wide messages on your intranet and voicemail system so employees who have the means can access the information. Designate an emergency response team and assign each team member a list of employees to contact. Tip number 3, do you distribute your checks via paper or electronic deposit? The Fair Labor Standards Act requires employers to pay employees the minimum wage due on their regular payday. If you think the storm will impact your payday, consider paying employees early. Contact your payroll company or bank to confirm that they can send electronic payments after the storm. Tip number 4, should you shut your business down? You may not have a choice in reality. Local authorities may order businesses to close or the area to evacuate. Your landlord may require all tenants to vacate the building prior to the storm. If you decide to remain open during the storm or to open immediately after the storm passes, remember OSHA's General Duty Clause. You must provide a workplace that is free from recognizable hazards that are likely to cause death or serious injury. Tip number 5, and this one's going to have lots of subparts, compliance with the Fair Labor Standards Act. Keeping track of hours that your employees work. If you rely upon an electronic timekeeping system or employees will work from home, make sure you have an alternate way to record hours worked. As I already mentioned, make sure you have arrangements to pay employees at least the minimum wage on the regular payday. How do you pay your exempt employees? Usually, to qualify as an exempt employee, you must pay the employee on a salary basis. This means that the employee is entitled to his or her weekly salary for any week in which the employee has performed any work. If your business closes for a few days during a hurricane and the employee performed any work during that work week, the employee is entitled to his or her entire weekly pay. However, the employer can require the employee to use PTO for days where no work was performed. If the employee has no accrued PTO, the employer must pay the employee. If your business remains open or open shortly after the storm and an exempt employee chooses not to work, you can treat that day as a personal absence and either dock the employee a full day's pay or require the employee to substitute paid leave for the absence. However, if the employee performs any work that day, you must pay the employee the full day salary. And remember, you cannot dock an exempt employee for a partial day absence, but you can dock his or her accrued PTO. How do you pay your non-exempt employees? Employers must pay non-exempt employees for all hours they actually work, including any work from home. That's why it's so critical to have accurate timekeeping. If there is no work for a non-exempt employee due to the hurricane, you are not required to pay wages, with one exception. A non-exempt employee paid under a fluctuating workweek scheme must receive the full weekly salary for any week in which the employee performs any work. That's my list. The pandemic has probably taught you to be flexible and nimble. You'll need the same skills after a hurricane. Here's to an uneventful hurricane season.
In our final What Keeps You Up at Night segment, shareholder Andy Rodman speaks with Paula Allen, Vice President of Human Resources for First Service Residential Florida, the leading provider of residential property management services in all of North America. The company manages a wide range of residential properties, including large-scale master plan communities, luxury high-rises, single-family homeowners associations, and active adult communities. While she's helping to keep residents sleeping soundly, let's see what keeps Paula tossing and turning.
I have the pleasure of representing First Service Residential and working with my good friend Paula Allen, Vice President of Human Resources. Paula, you have 7,000 associates who work at 1,700 different locations, and those locations are the properties that you manage. I can only imagine that going into COVID that presented some challenges. What was your biggest challenge or biggest obstacle or biggest fear going into COVID?
My biggest fear in the very beginning was keeping those 7,000 associates safe as they were doing their jobs, because as you know, Andy, we're an essential business. And so they went to work every day taking care of our residents and our properties.
And they're actually working at properties where residents live, residential communities.
Absolutely. So when everybody was home, we were working in their homes alongside them, and again, keeping everybody safe and making sure that we were updating protocols and communication. That was a big focus for us last year.
How did you maintain communications with your associates throughout the COVID period?
We did jump to technology, like a lot of companies did, but we relied on our on-site leadership teams to take all of the information that we would give them from a virtual perspective to property to then communicate with the associates and with the boards and our residents.
Have you learned anything through the COVID period that you're going to take with you and change your operations going forward?
From an HR perspective, yes, very excited that we learned we can take some of our interviewing virtually, new hire orientation, onboarding, training. So in a decentralized model with 7,000 associates and a leadership team, anything that we can do that makes the lives easier for our property managers. And so doing some of that training and even our development programs virtually is a learning we'll take forward.
Do you also have associates working from many corporate offices throughout the state?
Absolutely. And like everyone, when we all went home and worked virtually, we did that as well. Slowly but surely, we're bringing associates back to the office. Even our corporate offices never closed. So when we were able to safely, social distancing and wearing masks, bring people back to the office, we were able to do that. And we continue to have a hybrid model, safety being the most important thing. And from a culture perspective, we find people really happy to be back in the office and seeing each other in person and not virtually.
Do you foresee any changes in the way that you conduct onboarding of new associates going forward?
We learned that we were able to hire and onboard virtually. And I think that a hybrid model in our corporate offices will be the same. I myself have hired some new people during COVID, and I'm very happy with how we did that and what we learned and how fast we learned. And again, keeping our culture and our values at First Service intact helped us succeed.
Paula, were you surprised at all about your ability to manage human resources throughout the pandemic?
That's a great question, Andy, and I have given that thought. And I'm going to say I was not surprised. But I wasn't surprised because I have such a stellar HR team that supports an outstanding leadership team. And our ability through culture, through our focus on people, our focus on safety, and what our values, what we live every day, had us executing on everything that we needed to. And again, the most important thing from a safety perspective, just an outstanding team.
Well, thank you, Paula, for meeting with me today. It was great to see you after a year absence, and look forward to working with you going forward.
And Andy, I want to thank you. Our 6 years together built a solid foundation for our jump to virtual. You were there every day, anything we needed as a team. And again, thank you so much for your partnership.
My pleasure. Thank you.
Throughout the program, we've been hearing from veteran Stearns Weaver Miller attorneys. We thought it would be good to hear from some of the newer attorneys, as they may have a different and fresh view of the current business and legal landscape. I'm joined by 5 attorneys in their 30s to get their thoughts.
I'm sorry, Lori, I'm not 30.
Oh, I stand corrected. You're a youngin'. Okay, near 30? Close
Let's
enough.
say that.
Okay. 5 attorneys approaching or in their 30s. And now to be clear, just because they're younger doesn't mean they're inexperienced or uninformed. Of course not. In fact, these attorneys are frequent writers and speakers on all sorts of labor and employment topics. Very impressive. And they are leaders in various professional and community organizations. So please meet Paul Crusett. He is also the co-creator of a bi-weekly podcast titled Story of Miami that chronicles the city's history with the goal of forging a more united community. And next is Giselle Gutierrez, right here. She is a shareholder and the current co-vice president of the Cuban American Bar Association, or CABA, where she served in various positions since 2016. Giselle also serves on the executive board of the Young Lawyers Division of the Florida Bar Board of Governors, representing the 11th Judicial Circuit. Busy lady. And then Melanie Lightman right here is a shareholder out of Tallahassee, out of our office there. And she's also the current secretary for the William H. Stafford American Inn of Court, as well as for the Board of Directors of America's Second Harvest of the Big Bend. Tom Rain, who's approaching 30, is the most recent addition to the firm's labor and employment group, having graduated with a joint JD and MBA in 2020. Yes, he had to do both. Great. And Stephanie Turk, right here on my left, is the current secretary of the South Florida chapter of the Federal Bar Association, one of the largest chapters in the country. And she has served on the organization's board of directors in various capacities since 2017. And yes, for those of you who are wondering, she is Bob Turk's daughter-in-law. So thank you all for joining me right here today. And I'm interested to hear your take on the different trends and questions that you're seeing from employees right now in your generation and what you think may change in the future. So looking into your crystal ball, what do you see for Florida's workplace looking into the near future?
Well, hopefully we're still all above water.
Yes. Well, let's hope.
Thankfully, for the time being, we are above water, and we're surrounded by beautiful beaches and great weather, which has always attracted people to Florida. I think that with the growth of remote work, which really took off during COVID, you're going to see a lot of workers have more flexibility as to where they're deciding to live. I've spoken to many friends and businesses alike over the last year who have been telling me that the workers are increasingly no longer required to live in the same city, state, or even country in which their employers are located.
And this whole past year has just shown us, as you say, how prevalent it is, how we can all do it. We've all really kind of figured this out. Stephanie, can you reflect on how the court system has adapted to all this and what changes, if any, you see continuing after the pandemic?
Absolutely. The courts have adapted really well, and I think it's been pretty comforting to see how quickly they shifted to remote proceedings. And I think generally cases have been managed pretty much the same, with the exception of remote hearings, depositions, and mediations. Things have stayed pretty much the same. But more recently, and perhaps it's because of access to the COVID vaccine, we're seeing some of the in-person proceedings and trials return. But one thing that's here to stay, I think, is the remote proceeding. And so for brief or non-evidentiary hearings, I think those will stay remote. But for evidentiary hearings or trials, I think the preference is still for those to be in person. But everyone's going to be dealing with the backlog of trials.
So true.
And so, either your case is going to come to a screeching halt when it would have been set for trial, and so there might be delay. We think that's probably going to force more settlements.
And then, Tom, what do you see in the workplace?
Yeah, so Lori, it's not just the courts that are trying to decide whether to come back or to stay at home and be remote, or maybe a hybrid type system. I think that's one of the #1 questions for employers right now over the next few months as people get vaccinated. And one employment law specific issue that I think all employers will have is deciding whether their employees' physical presence in the workplace is an essential job function. So over the past year, everybody's been home, and for good reason, right? But as we start to come back, an employer will have to answer the question of a sick employee who wants to now work from home because they have for the last year, who says, why can't I just work from home while I'm sick as a reasonable accommodation? And so employers will have to come up with a business justification for why that employee must be in the workplace. And I think employers have also seen a benefit of flexible schedules, kind of like what their employees are experiencing. So for employers who, with the remote work experiment, I think what you'll see is more flexible schedules and possibly the 4-day work week, which has been experimented with in the past. And there have been many businesses who have have seen success with this.
So these flexible schedules and working remotely, maybe a 4-day work week, I mean, these are all big perks. Melanie, what other perks, if you will, are younger people looking for in jobs?
Yeah, absolutely. As Gen Z and millennials become a bigger component of our workforce, you're starting to see startup culture become more prevalent. Things like an open workspace design and increased collaboration, and even integrating play into the work environment, like ping pong tables or video games or soft serve machines, etc. And those are really attractive to the younger generations. They can be a really valuable recruitment tool. Although as employees begin to return to the physical workspace post-COVID, it remains to be seen how that affects this trend towards a more open workspace design. And continuing on with employee satisfaction and employee morale, diversity has become a really key issue lately. Employees like to look around and see somebody that looks like them in the workplace. They feel valued, they feel respected, they feel represented.
Definitely, and employers have really had to think outside of the box to figure out what perks are going to incentivize their workforce or be able to retain their workforce, because they've been pulling them out to companies that are thinking about these issues. And one of these perks is unlimited PTO. And I know when employers first hear that, they're kind of like, what do you mean? Is my workforce going to be gone for 2 months? Just take August off like we're in Europe? And that might work for them if they get all their work done. And I think that there's certain guidelines that can be put into place. But what employers have seen, along with a flexible work week, is a lot of productivity, increased productivity, efficiencies. People want to get their work done as soon as possible so that they could take that week of vacation off. Another emphasis that employers have had in the workplace for unique benefits is a focus on health and wellness. And that's becoming more and more important. And not just little perks like a meditation app that some employers do or a yoga class, but really an open environment where people can talk about their mental health and wellness, not feel judged, feel accepted, and feel like the company really values that. So, I mean, whether we're talking about bring your pets to work or concert tickets, employers are definitely getting creative.
That would be fun. I could bring my little Labradoodle over here. Yeah, that would be fun to do, always. And I've even heard some buzz recently, Paul, that some younger employees are looking to be paid by Bitcoin or crypto. Could we really get to that?
Yeah, I think that might be a bit more far ways off than some of the benefits Giselle was discussing. But we have heard several employers consider this option. Just recently, the mayor of Miami put forth a proposal that would have allowed city workers to choose to be paid in Bitcoin. This is sort of part of the mayor's overall strategy to make Miami a very tech-friendly and crypto-friendly city. I think the mayor may have been jumping the gun just a little bit without speaking to his employment attorneys, because for the time being, it's likely that paying employees at least entirely in Bitcoin is not legal. The Fair Labor Standards Act requires that employees be paid in cash or negotiable instruments, which is basically a fancy word for a paycheck. The Department of Labor has yet to weigh in on whether cryptocurrencies qualify as cash or negotiable instruments. But the IRS, a few years back, issued guidance, and they took the position that cryptocurrencies were considered property, not currency.
There's so many changes in the tech world, if you will. I mean, Tom, what other issues come up tech-wise?
I mean, you just go to the grocery store and you see the self-checkout robots. I just see a rise in robotics and automation coming.
There's even been some chatter about artificial intelligence replacing attorneys. And while there are certain AI tools that are useful for attorneys, like document review and research that can help make the attorneys more efficient, the AI is at this point pretty ill-equipped to take on the role of things like litigation. So never fear, your Stearns Weaver attorneys will not be replaced by robots anytime soon.
Good.
But you very may well see employees looking to unionization to try to protect their jobs from robotics and automation.
But in the TV business, unions are almost gone at this point. Do you see unions coming back in some way?
Just recently, Amazon was in the national news because workers at one of its warehouses in Alabama were trying to unionize. They held a unionization vote, and that vote actually failed by a significant margin, But I don't think that indicates that the unions are going away anytime soon. In fact, I think they're actually emboldened. For one, labor issues have really sort of come up to the forefront of the political agenda of the Democratic Party. So I think you're going to see a movement on the legislative and political fronts going forward, at least from the Democrats. Secondly, and I think just as importantly, whereas big companies like Amazon, Walmart, McDonald's, they have massive war chests with which to combat unionization efforts, smaller companies simply don't. Labor law is incredibly complex. It's full of major pitfalls. Just to give you one example, federal law protects workers' rights to engage in what's called concerted activity, which includes being able to talk to unions, members of unions, and even amongst themselves about unionization, about other terms and conditions of employment, and even if an employer would rather not have a unionized workforce, they're significantly limited in their ability to interfere with those rights.
So when it's not union related, maybe something to do with all these social injustices and social issues we're seeing now, can companies still interfere or have policies to limit how much their employees can talk about this in person or on social media?
Sure, Lori, and employers can invoke those rules. And in fact, we're seeing more and more employees wanting to express themselves. They want to carry on these conversations about politics in the workplace and on social media. And although most private employers probably know that employees don't have a constitutional right to free speech in the workplace, employers still have to keep in mind that there's other federal and state laws that do offer workers protections for some speech under certain situations.
And I would think with social media too, it depends if it's your personal account or if it's a work account.
Right.
You get into a whole nother gray area there. And then what does this mean for a private employer?
So for private employers first, employees are subject to the employer's private rules. The First Amendment doesn't offer any protection. So generally speaking, a private employer can discipline an employee for something that person says as long as the employer is consistent and doesn't discriminate in its decision making regarding the discipline. But, and we know there's always a but, the employer does have to watch out for other laws that could offer protection and also think about the business implications of taking any action against an employee. So let's just say, for example, you have 5 employees who come to the workplace and they show up in a button with a political message. First, call your lawyer before you tell them to take off the button, because among other reasons, you may have to allow them to wear that button because it could be considered protected speech under the National Labor Relations Act. But going beyond that, we think employers need to consider, before taking any action, what message is this sending to employees? And what sort of culture do we want to foster here at our company? And so, keep in mind that the same answer, it depends, also applies in the social media context. This is probably as good a time as any to, perhaps review or revise employee handbook policies that touch on things like this, dress code, social media, political speech, just to make sure it's clear to employees what's protected and what's not protected. The bottom line is to be consistent, as with all personnel actions. Call your lawyer to make sure you're not violating the law, and then think about how it's going to impact your business.
I see this a lot. You have a candidate come through the door, you interview them, and the first thing an employer goes to do is check the Facebook or the Instagram. And I got to really caution against that. We've seen a lot of discrimination lawsuits where a candidate who ultimately wasn't hired comes back and says, well, you didn't hire me because you saw on my Facebook XYZ happen. And it could be for disability discrimination or race or sexual preference. And, the employer says, well, I didn't consider any of that, but the knowledge is still there. And so they get into some hot water with that. The other context we've seen employers getting into hot water with social media use is in what Paul was saying, when he's talking about the concerted activities of the employees who might want to unionize. You can't have, for lack of a better word, a stalker employer checking everyone's Facebook because they have a right to that concerted activity. On the other hand, as Stephanie says, there's always a but. Social media for employers has also proven to be a very useful evidentiary tool.
Always. The pros and the cons, no doubt. And on the subject of getting caught for not following company policy, let's bring up this other big topic of medical marijuana. I mean, what impact are you seeing there, Giselle?
Well, as most of the employers know, there has been legalization of medical marijuana in Florida for certain conditions. But the issue is that there's still this federal law that you can't really reconcile with the state law, which says that you can't use marijuana. And so employers have had a tough time. You know, my advice is still to have a policy. If you want a drug-free workforce, have a policy and apply it consistently. As of right now, the legislature hasn't been able to really pass any laws in Florida to protect some of these people who need to use medical marijuana.
And tacking onto that, you know, while Florida has not yet passed a constitutional amendment allowing for recreational marijuana, and the last effort to get it on the ballot failed, that is definitely something we see as a recurring issue. I don't think that issue is dead by any means, and that will create similar confusion for employers, although not necessarily involving some of the disability aspects that you would see with medical marijuana for employers, but certainly on a broader scale. Now, of course, there has been some momentum at the federal level to either decriminalize or legalize marijuana entirely, and that would, of course, clear up the entire issue for employers. But we shall see what plays out at the federal and state level going forward with medical and recreational marijuana. And of course, continuing on with a legislative update from the Tallahassee office, there were a couple of big laws that failed in committee, but that we do expect to see again. One of the biggest ones was an amendment to the minimum wage amendment, where the legislature was trying to restrict the minimum wage expansion and to eliminate people who are under 21, former felons or convicted felons, and those who are considered difficult to employ. One of the bills that did actually pass is an expansion of a veterans employment and training program. So as that begins to roll out, some employers should really expect to see a lot more higher qualified veterans rolling in as job applicants. And forecasting to next year's session, it's an election year and they're going to be redistricting. So we don't expect to see a lot of activity, but stay tuned. Tune into next year and you'll see if my forecast holds true.
Melanie, thank you for coming all the way from Tallahassee.
Absolutely.
Down to Miami and Fort Lauderdale, this South Florida studio. And our audience is all over Florida. We know they're so in tune with everything you're talking about. The whole legal landscape is really changing. So thank you all so very, very much for being here today. Thanks for being with us.
Thank you.
Thank you, Lori.
Thank you so much for joining us today. With the pandemic, social justice movements, and the new Biden administration, there is certainly plenty of information to cover.
Well, we plan to have several follow-up webinars that will go in more depth about some of the topics discussed today, and others we didn't even get to discuss. So be on the lookout for an email coming soon that will allow you, one, to request future topics for future webinars, how to obtain Florida Bar CLE, SHRM, and HRCI credit, and you can request copies of our annual pocket guide, a go-to alphabetical resource on Florida employment laws. Now, we hope this program has helped you learn how to better juggle some of your new roles. For more tips and important updates, don't forget to sign up for our labor and employment law blog, belaborthepoint.com in English, or in Espanol, cafeconlabor.com. So I look forward to seeing everyone again next year in person. Thank you for joining us.
You're doing it. I love it. Oh my gosh, it's great. Look forward to seeing you next year in person.
So, if I can.
Oh no. We'll see you next year.